Well, I always have a discussion with my clients about when they need just a simple will or a trust, and it takes the form of a control issue. So basically we're talking to the client about whether probate is an issue that bothers them or not. Probate is explained to them in terms of a judicial process, that there's a time factor and an expense factor involved, and of course the loved ones that are left behind have to deal with the judges and the attorneys. If that is something that is not bothersome to the client, then I think they're a perfect candidate for a will. And by the way, the will is the easiest, cheapest, fastest thing to put in place, so that appeals to some people. If a person dies without a will in Texas, we have a state statute that handles that situation. It actually has a long, convoluted name. It's called the Statute of Descent and Distribution, and the law itself is just as convoluted as the name implies. It's basically a set of it's an outline of words that if you put it into a flow chart would show you where assets would go based upon different situations, like, was I married only once? Was I married twice? Did I have children? Did I not have children? So that state statute would dictate where assets would go if one does not have a will, and it may or may not be exactly what the client wants. I think there are times when someone can draw up their own will. I think that they just need to study a little bit concerning the proper protocol. They need to know, for example, that a proper will in Texas requires 2 witnesses and a notary signature. And I might add that for those people who already have a will and are thinking about changing it, the same protocols that went into drafting or signing the first will actually have to be maintained in the changing of the will. So you cannot just write on the existing will and make changes. The other documents that a client might consider in addition to a will for a good basic estate plan might be 4 other documents. The first one would be what in layman's terms we might call a financial power of attorney, more properly called a durable power or statutory durable power of attorney here in Texas. This is a document that gives someone else the power to make financial decisions and take care of financial matters for you if you can no longer do that for yourself. The second power of attorney that one might consider is a medical power of attorney. And that is a document that provides the power to someone else to make medical decisions for you if you can no longer do that for yourself. And it's very important in that document that we have a HIPAA release, which allows the person you've designated to make medical decisions to actually access your medical records. Otherwise, they might find themselves in a position where they cannot. The third document that I would say that someone should have in addition to a will is a directive to physicians. This is the one that people joke about, pull the plug or keep me alive forever, but what you're doing in effect is taking the burden off of your loved ones so that they do not have to make that decision, and that is a life and death decision, not a medical decision. And the last one that I would recommend that people have in addition to a will is a declaration of guardian, which would allow them to designate who their guardian would be if they ever became incapacitated, and that person gets to decide whether they go into assisted living, whether they stay at home and have care come in, and issues of that nature. If you have a will, it does not help you avoid probate. In fact, just the opposite. Assuming that there are assets that are subject to the will requires probate. So that means that we have to go through the process of dealing with attorneys and judges. And as I've mentioned before, we're dealing with a time factor and an expense factor. If you have a will, it is subject to being contested. Contested is a word that attorneys use to mean challenged. So if a certain heir gets wind of the will, and wills are public, they themselves get filed in the courthouse, and they look at the will and they are not satisfied with what's in there, if they think they have a valid claim, they can file a suit or a challenge, what we call a contest, against that will, and they can ask that the terms of the will be changed along the lines of whatever their request is. I think it's a good idea for clients to have their estate plan in general reviewed every 2 to 3 years. life situations change. We have births, we have deaths, we have marriages and divorces. And so it's a good idea just to have every 2 to 3 years, basically have that reviewed. And then whether the will itself needs to be changed or not depends on whether those circumstances warrant the change. Well, I would say that, first of all, clients need to understand that a will does not control all of their assets. Many times when I sit down with people, they think that the will controls the investment account, the bank account, the house, and sometimes it does and sometimes it doesn't. There are many different types of assets out there, such as life insurance, retirement plans, and a lot of others that a will does not necessarily control. So in order to do a good comprehensive job of estate planning, you want to make sure that you look at every single type of asset and talk to an expert about what that asset entails in terms of passing it on to your heirs, because the will may not cover it. You may need to look at some sort of additional documents to cover those types of assets.